Imagine a situation where you are angry at your friend for something they've done, and enraged, you start screaming at them. What you don't know, however, is that your friend experiences panic attacks when someone speaks to them loudly. Frenzied, your friend slips and injures themselves. Do you think you are at fault here? You may not think so, believing in your heart that you are innocent. You didn't even lift a finger. But the thin skull rule says otherwise. According to this rule, yes, you will be held responsible for what has gone down. You may be puzzled hearing this, really confused even. But perhaps the case of R versus Hayward, 1908, can explain this better. In R versus Hayward, the defendant chased his wife out of the house, shouting threats at her. Suddenly, the wife collapsed and died. The defendant had not touched her, and yet he was convicted of constructive manslaughter by the court. Why was he held liable? The court had found that his wife had a rare thyroid condition which could lead to death, where physical exertion was accompanied by fright and panic, unbeknown to the both of them. It was held that since the wife was more vulnerable than an ordinary victim, the defendant was fully liable. The general rule, therefore, became that the defendant must take their victim as they find them, or in other words, their liability is dependent upon the disposition of their victims. For more information on causation and the thin skull rule, visit the links given below.